I'm Dave Mullins. I'm a podiatric surgeon and healthcare attorney in Northern California, and I'm the author of the book How to Win Medicare Appeals, published by the American Bar Association. This is episode number 11 of the podcast based on that book. Let's get started. Let's return to the patient whose hospital status was changed from inpatient to outpatient despite having been in the hospital for more than several days. Once the hospital changes that patient's hospital status, if the patient only has Medicare Part A, all of the hospital charges going forward will be the financial responsibility of the patient. Has anything been done about this? Fortunately, the answer is yes. Take a look at the Center for Medicare Advocacy website. Go to the top of the page under litigation and pull down the case formerly known as Alexander versus Azar and now known as Barrows versus Becerra. Where is the Alexander versus Azar, now known as Barrows versus Becerra case at this point in time? After more than 7 years of delay on the part of Medicare's attorneys, a bench trial was held in 2019. Bench trial means that the trial was held in front of a judge without a jury being present. And in 2020, the federal district court judge presiding over that trial issued his decision. And the judge ruled in favor of the plaintiffs. In essence, the judge said the denial of a Medicare beneficiary's right to appeal their change in hospital status is a denial of due process. I think that's kind of a no-brainer. That's obviously what it was before that case went to court. What did Medicare do? Medicare appealed that decision. And in January of 2022, the Second Circuit Court of Appeals in Manhattan sustained the federal district court judge's decision in that case. What will Medicare do now? Meaning, will Medicare take this case to the Supreme Court? I don't know. But people make stupid decisions all the time. Why am I bringing up this formerly known as Alexander versus Azar, now known as Barrows versus Becerra case? And the name change in the case was due to the fact that Alexander was one of the plaintiffs who died, and therefore another plaintiff, Barrows, took Alexander's place. And Azar was the Secretary of Health and Human Services under Trump when the case started, but when the case ended, the Secretary of Health and Human Services was Becerra, the current Secretary of Health and Human Services. Why am I bringing this case up? I want to disabuse the 2 or 3% of you who think that if the providers would just behave appropriately, everything would be fine. That is unfortunately not true. I also want to wake you folks up to the opportunity sitting right in front of you. Every Medicare denial should be appealed, and you folks are in the best position to play a huge and personally profitable role in these Medicare appeals. There's no reason why you shouldn't, and every reason why you should be representing the Medicare providers regarding these denials of payment. It's good for the patient. It's good for the provider. It's good for Medicare. And it's good for you. Does Medicare like or dislike a particular specialty or provider? No. Medicare doesn't like or dislike any particular specialty or provider. Medicare just doesn't have the money to pay for the care provided to Medicare patients. Or in other words, Medicare doesn't have the money to pay its bills. How will your referral sources find out about your Medicare appeal successes? You're going to post your good news in the form of the redacted administrative law judge written decisions on social media like LinkedIn every time you win. Redact means you're going to black out the identifiers for the patient and the provider throughout the ALJ decision. And then you're going to post that redacted version on LinkedIn. The difference in advertising power between someone who says they know how to do something and someone who can prove they know how to do it is, as Donald Trump used to say, huge. You should take advantage of this opportunity and post your wins in front of the administrative law judges on LinkedIn. How much should you be charging your Medicare provider clients and on what basis? I think you should be charging not less than 20% of the Medicare allowed amount for each of the claims at issue in the appeal. And you should be charging not more than 40% of the Medicare allowed amount for each of the claims in the issue, each of the claims at issue. Why not less than 20%? If you're charging less than 20%, you're probably not taking this very seriously. That means you're not going to put the time and effort into doing the work that needs to be done. In addition, if you're charging less than 20%, I think your provider client's not going to take you very seriously either. Why not more than 40%? Once you reach the threshold level of 50% on a contingency fee basis representing a provider client, you're getting into no man's land. And I'll tell you that if your representation agreement calls for 50% of the Medicare allowed amount to be paid to you for each of the claims that you successfully appeal, and then you win the appeal, and that provider is sitting there writing that check out to you for 50% of the Medicare allowed amount, I'll tell you that what that provider is thinking is something like this. You mean to tell me that you don't have the education, the training, the experience, or the medical malpractice liability exposure regarding the treatment of any of these patients, but you think you're entitled to 50% of what Medicare pays for these services? I know that that's what they're thinking when you're at 50%, because I've been there. Next point. Obviously, if you're doing this at 20% or 40%, or unfortunately at 50%, you're doing this representation on a contingency fee basis. And you should be doing your representation on a contingency fee basis. Why? Why contingency fee? Let's say that your provider's denied payment, and you agree to represent that provider on an hourly basis instead of contingency fee basis. And then you lose the appeal. Now you have a provider who was denied payment for the services that were medically reasonable and necessary. And that provider, in addition to not being paid for those services, now has to pay your hourly fee for the representation. You have a very, very unhappy provider who will probably be somebody else's client the next time around. Your first words to the provider, hopefully, were something like, if I don't win the appeal, I don't get paid. Because when you first started representing the provider, you were doing the representation on a contingency fee basis. You want to stay with that contingency fee model if you possibly can. I hate to think about the provider client who, having lost an appeal, and who being told by you that you're going to forgive them the hourly fee and that you want to go back to the contingency fee for that appeal so the provider doesn't owe you anything. I think that would be a smart thing to do. But hopefully the provider is not going to look at you and say, you know what, from now on, let's do all these cases on an hourly basis. Unless you lose, then let's call it contingency fee. Sure hope that doesn't happen to you. It's never happened to me. But I can tell you that that would be a provider who needs to go to law school. Want to do Medicare appeals, but you need help? I will mentor you regarding any Medicare appeal that you need help with. If I can answer your question off the cuff, or by citing the page number and question and answer set number in How to Win Medicare Appeals that will give you the answer to your question, I'll be happy to do that. And the clock will not be running. Or, if you really want me to partner with you to do a case, connect with me and we'll discuss it. How to contact me. Connect with me on LinkedIn. If we're not already connected, put my name in, ask me to connect. I'm going to say yes. Once we're connected, you can send me a short message telling me what the case is about, setting up a time for a phone call, and we'll go from there. How are we going to structure the rest of this podcast? We're going to use the question and answer sets in How to Win Medicare Appeals. First, we're going to do the first level redetermination appeal in complete detail, then the second level reconsideration appeal, and then the third level administrative law judge appeal. Then we're going to move through the topic of Medicare audits, and finally finish up with a summary of how to win and how to lose Medicare appeals. That's it for today. I'll see you the next time.